planning. That was my segue. Dave Zumpano in studio, the Estate Planning Law Center, and look, it's right in the name there. But Dave, we were talking off the air. Let's go to something, I guess, simple, in nature, but maybe not all that simple when it comes to, people wanting to know the difference or describing the differences. But wills and trusts, how about that?
Yeah, I always tell people, trust me, I'm a trust lawyer. Right? But
trust you?
Trust I will. Look at that.
But you're not from the government. How can we trust you? Before you start, Dave, I got to say you look very festive. You got a Hawaiian shirt.
Well, thank you. I figure I got to really milk this summer out as long as we can get it.
I don't blame you.
Yeah, it's nice when you hide behind the radio. You don't have to.
Put a smile to my face when I saw you.
I thought I
expected to hear some Hawaiian music and
see that going. If it cheers you up, that makes it. It does
cheered me
job.
up, so it worked.
Awesome.
It worked.
So the question is will versus trust. People say, well, I'm all set. I have my will. Am I all set with a will? Why would I need a trust? And then you get into revocable trust and irrevocable trust, so people start to get overwhelmed. So let's just break it down. Basic documents, right? Will. What does it do? It makes sure that after you're gone, it gets whatever you have to the people you identify. All right? Your stuff, we call it, right? Your assets, your house, your car, your bank accounts, whatever you own, it gets your stuff to the people you want to have it. Now, couple distinctions with a will. A will is only valid after you're dead, right? Seems obvious, but you'll see the distinction when we talk about trust. A will is only valid after your death. That's the first distinction. The second distinction is for a will to be validated, it must go through a process called probate. Probate is a legal process with the courts. After you die, your loved ones, whoever you appoint your executor, is not automatic. People go, well, can't my executor just go do what they have to do? No. The executor actually has to be appointed by a judge, which is this process called probate. So after you die, the person who appointed in your will go hire a lawyer. The lawyer will then go to the court. They will complete a probate petition. It's about 8 pages, and it tells the court 4 basic things. Who's the dead guy? What did the dead guy own? Who are the dead guy's beneficiaries, and who are the dead guy's heirs?
So is that what the judge says?
Yeah. The dead guy. I swank it down to make it for everyday folk to understand.
They're interpreting the document, basically.
Yeah, I'm interpreting the document in everyday terms.
In law, we use the term deceased.
Mm-hmm. Yeah.
It's a more softer tone.
The deceased instead of the dead guy. Could be the dead woman, too. So,
right.
So the distinction there is the difference between the beneficiary and the heir. So what is an heir? So whenever I give my workshops, I question people. I say, how many people in the room have heirs? And everybody raises their hand. And all of them are incorrect. None of us here have heirs. And the reason why we don't have heirs is because we're still alive. Right? Heirs aren't determined until you die. And that gets a laugh out of everybody, but here's the distinction. If you're in a car accident and you die 5 minutes before someone else in the car, they're your heir. If you die 5 minutes after, they're not. And so there's so many distinctions in the law that can complicate a probate because we don't know who's going to be alive and who's going to be dead when you die. And we don't know the circumstances of death.
Right.
So what happens is, under the law, we have to go, after we file this probate petition and the death certificate, we have to go get what's called a waiver and consent from all of your heirs. Heirs are the people who would have inherited if you died without a will. So even though you died with a will, the court says, no, we have to go check with all the people who would have inherited if you died without a will so that they have a right to come forward and challenge the will.
Right.
Right? So you got to get all your heirs to sign off. What does that mean? Your heirs in New York State is your spouse and children. If you're married, it's your spouse and children. If you're married, it's your spouse. If you don't have children, it's your spouse. If you don't have a spouse, it's your children. If you don't have a spouse or children, it's your parents.
And Dave, before you go on from that, an interesting thing is when you talk about your children, that could be children from a different relationship, children born out of wedlock.
Yeah, and that's where it gets really complicated.
So people could have had a child out of wedlock before the person married, then had 3 kids with a current wife.
Well, they can also have had a child that they're not in relationship with. They don't even know where they are.
So you're also saying,
go find them.
You're also saying, though, Dave, that so the court may come back and have a different opinion on who's entitled to your stuff, in a sense, right? Well, so you might be so upset with someone that I guess would be the typically the next person in line, or someone who could or should benefit from your stuff, I guess, when you're deceased, and the court says, well, hang on a moment.
No, it has nothing to do
No,
with
no,
the
it's the
relationship.
law.
It's all.
Yeah.
It's subjective.
So here's what it is. You ready?
But I didn't mean to interrupt you. So
Yeah.
you were going on.
So
from
the will.
Then you went to the parents. Just go from
the
there.
parents.
Yeah.
So your heirs are your spouse and children. If you don't have either, it's the other. If you don't have a spouse or children, it's your parents. If you don't have parents, it's your brothers and sisters. If you don't have brothers and sisters, it's your nieces and nephews. If you don't have nieces and nephews, it's your grandparents. If you don't have grandparents, it's your aunts and uncles. If you don't have aunts and uncles, it's your cousins. And if you don't have cousins, it's your children of cousins. And if you don't have children of cousins, then your heir is the state of New York. So what happens is everybody says, well, if you die without a will, it goes to the state. No, it doesn't. It goes to those people we just said. So people say, well, what's interesting is people here listening who don't have a will, yes, you do. The state of New York has one for you. I just told you what it is. It's going to go to your spouse and children equally, though, which is a whole other challenge, right? Your spouse doesn't get it. 50% goes to each. So it gets complicated, and you're living by rules that have been established in law and it has nothing to do with you. That's why a will is important to make it your direction instead of the government. Right?
Well, and I wasn't commenting on Mark's situation. I was commenting more on the ability to contest the will. So, and I know that happens as well.
Let me blow your mind with this one. So, have you ever heard of someone contesting a will?
Yes, but
and here's how it happens. You ready? It's this simple.
I guess this is the understanding, which I don't necessarily grasp.
Here's how simple it is. You ready? When somebody has to probate a will, we have to go get a waiver and consent. That's a form where they waive service of process of the will, and they consent to the executor being appointed, okay? And we have to get that signed by all the heirs. So we send that to the heirs. As Mark says, you might have a child out of wedlock. We send it to him or her, and they don't sign it. They're officially contesting the will. It doesn't take any affirmative act.
Right.
It takes no act. And so now we have to bring another proceeding in front of the court to bring that heir into court to say to the judge, why they're not signing the piece of paper. And if they don't have a legitimate reason why, then the judge will overrule it and let the probate go on. So it's really quirky. But in case anyone hasn't figured this out, this is a lot of legal mumbo jumbo.
Sure.
A lot of lawyers, a lot of courts, filing fees, legal fees, costly, expensive. For those people that had the misfortune of dying in January, February, or March, they may not even be probated yet because of Corona. Courts were closed for months. Everything locked down. No access to assets of the deceased person. Very, very restrictive, very time-consuming, very costly.
So if someone is in that situation, other than the fact that maybe you had bills to pay and you were really hoping for that money, what's the downfall of like if everything is tied up right now and you're waiting to resolve?
Assets stay inactive. So what if it's an older person and there's a house to maintain?
Yeah,
Who's
right.
making sure the heat's on and it's in the middle of winter? Who's making sure the driveway's plowed if it needs to be plowed? How do we know the pipes aren't cracked? I mean, it's multiple, right?
Yeah.
And so the other thing is the morbid scavenger hunt, right? We call it the morbid scavenger hunt. Mom and dad died. What did they have?
Oh.
So kids are scavenging through the house looking for paperwork. And I got to tell you, there's nothing worse for the kids. It's not a fun thing to do.
Yeah.
And so that's why estate planning is also about consolidating, get everything together. When people walk out of our office, they have this binder with tabs that have everything there. So the family knows everything you've planned and everything you have and in one spot, you know.
Very beneficial in those times, for sure.
Yeah, so that's the will process. When you have a will, you got to go through this probate process. Now, once we go through all this, get everything signed, which usually takes 1 to 3 months if everything goes perfectly. It takes an attorney 1 to 3 months to get that done. It's taken a lot longer if you have heirs that are out of state. I had one that took 7 years because a woman was the youngest child of 11, and she was from Canada. So when we had to go find her heirs because she had no will, it was a nightmare. We had to publish in Canada. We had to publish in last known addresses of anyone. It was the craziest thing.
I was going to wild goose chase.
Yeah, Dave.
Exactly what it is.
Dave, is that
goose
you?
chase.
Do you put on like a hat, a fedora, and a trench coat, and go on a train riding through the
He
mountains?
just came back. Look, and he was looking for somebody in Hawaii.
Is that do you have to do that? Go on the ground hit the ground, and then just like ask people, hey, anybody?
Well, you do hit the ground. You literally do. You're talking to family, friends. Do you know anything about who the family was, where they were? And this woman was the youngest child of the youngest child of 7.
Which means
11.
that most of them are dead.
And she was 98.
Oh wow!
So they were all dead, but the court doesn't care. You got to publish, and so we're trying to find. I mean, what's the likelihood that she had any living cousin?
Right.
She was the youngest child of the youngest child of 7. So it's like she's like the last born grandchild. So even to find a cousin, she was 98. What's the likelihood? Didn't matter. We had to go publish in Canada. We had to go, and then there was court orders, and then, and there was enough money involved that people were fighting. So. It just gets crazy. Now, there's a much simpler way. A revocable living trust.
Right.
Okay? A revocable living trust is where you set up your rules. You don't use the government's rules. You use your rules. So it's like setting up your own corporation, if you think about it. If you have a corporation, right, you create a name for it, and then you operate your corporation. A trust is the same thing. You create a name for your trust. Most people name it after their name. In our office, we always use initials. So mine would be the DJZ Trust, right? So, and I would be the trustee, and I set my rules that say, okay, when I'm alive, here's the biggest advantage of a trust is it's valid now while you're alive. You don't have to wait till you're dead. The other advantage of it is it takes control of your assets, not after you die, but while you're alive if you become incapacitated or disabled. And it tells the trustee, we call it a trustee in a trust, an executor is in the will, the trustee is in the trust. It tells the trustee what to do with your stuff, while you're alive and well, while you're alive and not well, after you're gone, for the benefit of your spouse, for the benefit of your kids, and it can go on, and the rules and the instructions can provide protection.
A position the state would otherwise hold if you didn't.
And now we have no courts to go to, no judges, no affidavits, no waivers and consents required. It's all done in the privacy. I always say we never go to a courtroom. It's done in the privacy of our conference room or your living room. Mm-hmm. We'll sit down with the family.
Does that ever become an issue, Dave, where one child is the executor and one says, "Well, why not me?" or "Why him?" or
well, yeah.
Mm-hmm.
But you hit a sensitive issue because people say, "Well, who should it be?" And there's an old joke we say in the business. If it's always the oldest child, unless you're a teen, then it's the oldest male child, right? So, so sometimes the biggest thing about life and death that people need to hear, especially those people who are seniors and that might be listening this morning, parents play many roles. They're the mother, the father, the aunt, the uncle, the sister, the brother. But there's one role they don't really appreciate. They're the referee, right? When kids don't get along, who steps in? Mom and dad steps in, makes it all right. Well, imagine a game without a referee.
Right.
That's what happens when mom or dad die.
Right.
Okay, the referee's gone.
So
now it's like we got to hope everybody's playing fair. Mm-hmm. And here's the crazy part. Someone might be playing fair, but the other one perceives that they're not.
Right.
So it's not even a reality, it's a perception. And then you bring in the in-laws, and that brings in a whole nother level of challenge. So the way you really eradicate all that is just set up your own rules in a revocable living trust. And then we have irrevocable living trust. But a living trust is a trust you create while you're alive. But the benefit of it is it controls your assets as long as you fund it. Meaning fund it means you actually have to take your house out of your name and put it in your trust name.
And so it also takes out the possible interpretation or what you think mom and dad may have wanted.
Yes, because and I'll say this. Most lawyers do what I call boilerplate trust. They get them off the internet or they get them from a company or things of that nature. And they're boilerplate, which does about 80% of the stuff out there, right? But when you really look at it, looking at each individual family situation and identifying the key factors that create risk, we've been doing this 27 years. We've served over 10,000 clients. You begin to see the trends, and the questions
dad's car collections, mom China, something like that.
Or even the relationships, you check in on the relationships, and then you build in. One of the things we like to do in a lot of our trusts is we communicate mom and dad's wishes, like, it is not out of love and affection that I'm doing this, but rather because of this. And it helps explain, why they might be doing something that might not be equal, for example. They might not say everything's 50-50. They may say, Janie has been here for me the last several years of my life, day in and day out, taking care of me as I aged. So I'm giving this a little bit extra to her. So just to explain it so people aren't saying, Janie, you took all mom's money, and, because that stuff gets really, really heated.
Well, Dave, we have I don't know, 3 minutes maybe or so left, and
well,
so
I have a quick question,
sure.
Dave. Dave, do you believe Kim Jong Un is in a coma in North Korea right now? Do you believe he had a will set up?
I was going to make a really crazy comment, but it was political, so I better not do that.
We don't get political here.
Yeah,
so
we don't get political, huh?
No, we don't.
I was going to say, I have no idea.
We stay away from politics.
All I know, we haven't seen him physically in months, have we?
No. Apparently, his sister is now running the country while he's in a
but
coma.
I heard that back like 3 months ago. She was.
We heard his sister got him to sign a trust, made her the trustee and the beneficiary.
There we go. I
She-
like that.
Yeah, she gave him some.
And he
Turned
gave her
over
the
everything.
country. He gave her the country in his trust. Yeah. Hey, you get my country.
he finally said, "You can have it."
in North Korea.
Well, Dave, the last few minutes. I know a reminder. We spent some time on it last time you were in last month, but this ability for home care and to apply, this runs out soon, right?
It does, and I can't say it enough. And the biggest thing is home care, getting care in your home up to 24 hours a day or as little as 2 hours a day. As people age, so if you're parent, and I'm saying this, if your parent is at a point where you're worrying about whether they're eating, whether you're worried about whether they should be driving, if they're starting to use a cane, those are key indications that they're probably going to be eligible for this benefit, even if it's at a minor amount. As people age, they tend to forget whether they even ate breakfast or not. And then they don't want to take the hassle to cook something. And so that's when things start to deteriorate. Having someone come in a couple hours a day for socialization, to check the meds, to make sure they're eating is critically important, and it reverses the trendward down physically. So I cannot tell you the number of clients we have done this with and what a difference it's made for their health and for their longevity and their well-being. I mean, emotionally, they're engaging with people instead of sitting, all day long alone in many cases. That benefit, the ability to get it unconditionally, is going away October 1st. So we're down to the last month here.
Well, let's talk about that, 'cause that's important. I think, if I understand this correctly, that if you have you can only have a certain number of assets to qualify for that program.
Yeah.
It was about $15,000, right?
Yeah.
So if you
could have up to 100 if you're married through some.
But let's say
exceptions,
you're
yeah.
single and you have 115,000.
Right.
You could give away $100,000 today.
Right.
Have $15,000, and then on September 1st you could apply for this program.
Yes.
And there's no 5-year look back.
There's no look back. Correct.
Now, after the date changes,
After October 1st, there's going to be a look back.
The 5-year look back.
We have
that applies
3-year
if-
look back.
That it's 3 years.
3-year look back.
That's similar to what happens if you apply for Medicaid when you're in a nursing home.
Yeah, and
so
that's
why
gonna be a big
everybody
restrict-
has to make.
That's why
their
we've got
transfers
this
early.
little window. We got 30 days left here, basically. We have to file apps by October